I'm Tiffany Weber, and I am a North Carolina real estate attorney. Today, we're going to get into what the closing attorney does and does not do. So this is a common question that I get in my office of, does the attorney order the surveys? Or what is the attorney doing during the title search? So in our office with our engagement letter, we like to send a helpful checklist that says quite simply what the attorney does and does not do. But I know that that's not a standard form everywhere. So if you are closing somewhere and you're wondering what exactly is my attorney going to do, then this should give you a better idea of what goes into the closing process from the attorney's perspective. The first thing that the attorney is going to do upon receiving a copy of the sales contract is check the current owner that's on title. So that involves going to the Register of Deeds and determining who actually owns the property. Sometimes sellers may own the property in their company name, but they sign the contract in their individual name. For example, you might think you're buying from John Smith, but you're really buying from J. Smith and Associates Incorporated. So we have to check the deed to see who actually owns the property. And if it is actually a company, then we go to the Secretary of State to make sure that that company is still active and can actually transact the business and convey the deed. The next thing that the closing attorney does is establish the chain of title. So this means going back in the public records for either a period of time or since the last title policy was issued to figure out who has owned the property during that time period. Were there any easements granted, or were there any special considerations that we need to look out for? So this involves going back in time, like I said, to figure out who the property was bought and sold from during that time frame. Sometimes, if an owner has died before the next conveyance was made, that means looking at the estate file to figure out who the heirs are and making sure that all of the properties were properly conveyed during that time. And that also involves looking at the deeds to make sure that they were signed by the right people in the right places and actually notarized before they were recorded. After the chain of title has been established, then the attorney is going to look at the out conveyances. So this means looking at the grantor index in the Register of Deeds and figuring out whether the property or a piece of the property has ever been conveyed to someone else. So depending on the activity of the former owners, that could mean checking 5 out conveyances or several hundred, and it varies every single day. So there will be times where our title searcher has just a few out conveyances or legitimately hundreds to look through to figure out whether the property has been conveyed to someone else, whether in part or in whole. And during this process, we're also figuring out if there have been any deeds of trust granted on the property. So deeds of trust secure loans made for the property. And if there have been any, then those loans have to be paid off at closing. So we're checking to see if the seller has any loans to be paid so that the buyer can take clear title to the property. During this title search process, after the chain of title and the out conveyances have been searched and established, then the attorney is going to be checking all of the other systems. So that means checking for judgments, bankruptcies, liens, special proceedings, estate files, tax assessments. So basically any other lien against the property or any other interest that someone else may have in the property. So if there's a civil action or a judgment against the seller, then that judgment needs to be released prior to the closing. And if there are other agreements or other liens or other issues that need to be worked out, then those releases also need to be drafted and signed before closing so that the buyer can obtain clear title as well. The next part of the process is locating a copy of the restrictive covenants. Usually, your agent has provided you with a copy of the restrictive covenants prior to even going under contract for the property. And if they didn't, next time you buy a property, make sure you ask for those before you sign your offer. That way you can make sure that the property is not restricted against your intended use. So even if you don't have an HOA, you very well could still have restrictions. So these restrictions are going to determine what you can do with the property, so your uses, where the property or where the home can be located on the property. What are your setbacks? Do you have any special breed restrictions for pets that you can have on the property? So it's very important that during this closing process, you're looking at those restrictive covenants prior to the day of closing to make sure that what you want to do with the property is not restricted against. And finally, once the title process is completed, then the closing attorney prepares the loan documents in accordance with the lender's instructions. So the closing attorney doesn't decide the lender's fees and doesn't negotiate the lender's fees, but the closing attorney does make sure that all of those charges are accounted for correctly on the closing statement. Now, you go over the closing statement at closing because it is always possible that something is missed, either wasn't provided to the closing attorney or maybe got lost in the shuffle. So it's important to look at your closing statement before you put your signature on it to make sure that there isn't anything missing or that needs to be corrected. Also, as part of preparing the loan documents, the attorney makes sure that the correct legal description is attached to all the conveyance documents or deeds of trust, and then also make sure that the lender's final title policy is delivered to them in a timely manner. So this is not every single little thing that a closing attorney does, but it does give you a really good idea of what the closing attorney's responsibility is. Next, we're going to talk about the things that the closing attorney does not do, which means it's something that you or your agent is in charge of making sure happens prior to closing. The first thing that the closing attorney does not do during the closing process is order or perform any structural or home inspections. So we recommend that a buyer obtain all the inspections that are applicable to the type of property that they're purchasing. We know that it can be expensive, but this is a huge purchase, and you don't want to be surprised after you move into the home that there are structural damages or other damages that you could have figured out before you closed and avoided buying a property that's not suitable for your lifestyle or that you can't afford to maintain. So you should order your inspections because the attorney is not going to give you any sort of certification about whether the home is suitable, meets any codes, doesn't have any structural issues. Also, when you obtain the inspection, if you have any repairs that are requested, those should be submitted to and approved by the seller prior to the expiration of due diligence. So if you know you want to try to negotiate some repairs, please don't wait until the last minute to ask the seller for those repairs because you might find yourself in a tight spot and give yourself less ability to negotiate those repairs. The next thing that the parties are responsible for doing but that the closing attorney does not do is procure a survey of the property lines. So just because the lender does not require you to get a survey doesn't mean you don't need one. This is especially true where the property has not been platted, and that's often the case in rural developments. So the closing attorney cannot certify to you where the property lines are. Only a surveyor can do that. So if you don't obtain a survey, then you may not be exactly sure where the property lines lie. And then you also will not know whether there are any encroachments, either by the subject property that you want to buy or a neighboring property onto your property. If you don't get a survey, your title insurance company will not insure over any defects or issues that could have been discovered had you obtained that survey. And I'll give you an example of why surveys are important. A couple of years ago, a guy called our office begging us to help him because he had closed on a property in the North Carolina mountains. He didn't get a survey, and everyone in the transaction was not quite sure where exactly the property lines were. So this guy buys a property, he closes on it, he's out there trying to clear his lot because he wants to build a house on it, and the true owner shows up and says, "What are you doing clearing my lot?" So because this guy didn't get a survey, he was completely mistaken about the location of his property. He actually bought something about a quarter mile down the road, and that property wouldn't even perk, so he wasn't going to be able to build on it. So he called us and said, "What do we do? How do we undo this?" And in short, in that situation, there was no undoing it. He had bought a property, and if he had gotten a survey, he would know that it was not what he intended to buy and could have canceled the transaction before going through with it. So that is obviously a worst case scenario, but that is one of the big examples of why it's very important to get a survey when you don't know exactly where the property lines are. The closing attorney also does not certify as to any environmental conditions on the property. So if there's been any kind of contamination, if there are underground storage tanks for fuel, the closing attorney is not going to know that. So that's part of your obtaining any inspections that you need to make sure that there aren't any environmental conditions that are negative or that would require significant cleanup prior to closing. The closing attorney also does not tell you whether or not you're in a flood zone. We don't know, so you have to get a flood certification to find that out. And usually if you're getting a loan, the lender requires that a flood certification be obtained. So you'll find out during your loan process whether or not the property is in a flood zone. Sometimes your agent will tell you this before you ever go under contract as well. And if you are not getting a loan and your agent doesn't know whether you're in a flood zone, a surveyor can get you that information. So you can engage a surveyor, knock out the survey, and then also find out if the property is located in a flood zone. The next thing that it's important for you to do, but that the closing attorney does not do, is determine whether or not the septic system can accommodate a certain number of bedrooms. For example, if you're buying a vacant lot and there's no existing septic permit, then it's really important that you get a new septic improvement permit to determine whether or not you'll be even able to build on the home, or that you'll be able to build a home of the certain number of bedrooms that you want to be located on that lot. If there's an existing home on the property, the closing attorney does not certify whether it can accommodate a certain number of bedrooms, or whether you can increase the size of the home and then also increase the capacity of the septic to increase the number of bedrooms. So that's why it's important to obtain a copy of the septic permit, whether it's existing, or if you want to increase the capacity or build a new home, get a copy or obtain a new septic improvement permit from the county. The closing attorney also makes no representation about the availability or quality of a water connection to the property. So if the property has a well, you can get a well inspection to determine the water quality and then take any appropriate steps that you need to take. But often, as is in the case when you're buying a vacant lot, you'll have to contact the local government to determine how and what is necessary to connect to the public water system. So that's something that the closing attorney won't be able to tell you. We don't have access to that information. So it's either the local government that can tell you that if it's a public system, or a well inspector that can go out to the property and determine the availability and quality of the water at the property. The closing attorney also doesn't make any representations about the zoning of the property. You can determine the zoning of the property by looking at your local government's maps, or calling the town of Mooresville, like where we are right now, and just saying, hey, what is this property zoned for? Oftentimes the listing will tell you what the zoning is as well. But we have clients often say, well, I want to rezone the property. Will I be able to do that? That is entirely up to the local government. So we can't give you any representations about whether that's likely to occur. So if it's important to you that you want to do something with the property that's not permitted under the current zoning and you're going to have to rezone it, then you need to diligently inquire about that process with the local government and determine whether it's going to be worth it to proceed, because a closing attorney won't be able to tell you whether the government will or will not approve that rezoning request. Next, the closing attorney does not order your hazard insurance for you. So your homeowner's insurance, you will have to shop for and procure on your own, and then you'll provide a copy of it to the lender and the closing attorney prior to closing. Usually, if you've got a lender, the lender requires that you pay for your homeowner's insurance for 1 year, starting from the date of closing. So you're going to have that information in advance. Once you're deciding to buy a property, it's a good idea to contact insurance companies and start shopping around for the best policy and price for you. And finally, the closing attorney does not make any representations as to the property value. Only an appraiser can do that. So if you're getting a loan, usually the lender has an appraisal performed, and you'll get that information provided by the lender. You'll pay for that appraisal as part of the closing process. But even if you're not getting a loan, then you can have an appraiser come out and determine the value of the property prior to the expiration of due diligence. Appraisers are in high demand, just as are surveyors and inspectors and everyone else in this market right now. So once you're ready to start shopping for properties, then it's a good idea to get in touch with a local appraiser and determine their availability and how much notice you need to give them in order to get an appraisal done. So that is not all encompassing, but a really good idea of what the closing attorney does and does not do. So if you have any questions about whether the office that you are closing at engages in handling a specific service, make sure you ask them. But this is a good guide so that you'll know what is on you and then what the attorney is going to do for you during the closing process. Thank you for watching. If you like to watch videos like this about the real estate closing process, make sure you subscribe to my channel. I'm Tiffany Weber, and I will see you in the next video.